Good afternoon or good morning, everyone, depending on where you're joining us from today, and welcome to today's webinar. My name is Kate Chalker, and I work in the Sydney office with Adrian Bailey, who you can also see on the screen, the principal of our Sydney office. Today's webinar will be looking at testamentary trusts, which are created under a person's will, and Adrian today will be examining the effectiveness of those trusts, looking at estate challenges, asset protection, and also some tax considerations as well. So just before I get Adrian to dive into that topic, I will just run you through a couple of features of the system, just for those of you who may not have joined us before. So if you would like to download the slides from today's presentation, you can do that just by clicking on the Files button on the right-hand side of the screen, and you should be able to download the slides from that tab. We have had a few issues with that in the past, but I will double check to make sure that they're working, or if not, they will also come around to you via an email after today. There will also be a feedback email circulated after today's webinar, and we would really appreciate it if you could take a minute or two just to complete that survey. I'd also like to draw your attention to the webinar, which we have coming up in a fortnight. So that will be a little bit of a different format from our usual webinars. I think we're calling it a bit of an Ask the Experts roundtable discussion. So we don't really have a designated topic for that one. So we would love it if you could think of some burning questions that you might have for our principals. So Adrian, Brett and Paul will all be sitting down and joining us in a fortnight and answering any questions which you may have. So if you would like to give it a bit of thought, and I think at the end of next week, there will be an email going around just asking for any questions which you might like to submit. So yes, please have a think about any questions which you might like to submit for our next webinar. Because we would really appreciate being able to have a think about those before the next one. So without any further ado, I think I'll also mention questions. There's also a chat function on the right-hand side of the screen. So as Adrian is going through his presentation today, feel free to send through any questions which you might have, and I'll be happy to interrupt Adrian at an appropriate time and put those questions to him, or else there will also be time for questions at the end of the presentation. And Paul has just informed me that the slides are working fine, so there should be no issues there. And so I will hand over to you, Adrian.
Thanks, Kate, and hello, everybody. I'd like to welcome you after Kate's welcome to the presentation today on whether testamentary trusts work. Like many topics, this was a topic that was suggested by one of our attendees. So in all of our feedback emails, you'll see a thing at the bottom about topics that you would like covered. This one was requested specifically about a month ago, so that's why we're doing this presentation today. Fairly common client objective would be that they want to make sure when we're talking about estate planning that their personally held assets are adequately dealt with on their death. And also, depending on the nature of the estate and the nature of the client's wealth, quite often there's also the desire that those assets are protected for future generations. So not just the next generation, but for grandchildren perhaps, or great-grandchildren. Clients will often want to make sure that what they've built up during their life, particularly, as I said, if it's a large estate, that those assets are protected for the benefit of future generations. And also, maybe not forefront of the client's mind, generally it's protecting the estate. They're wanting to provide maximum tax effectiveness and flexibility. So hence a fairly widespread use of testamentary trusts and wills. So testamentary trust being a type of trust that's created under a will. We'll work through some of the mechanics and the features of them, as well as what sort of protection that they do provide, the taxation of them, so we can then really consider, do they work, and will they achieve the client's objectives. Our agenda today, first off, we're going to talk about testamentary trusts and general asset protection. So if we have assets that devolve via a testamentary trust, if the beneficiaries come under attack for a failed business, for example, or some other issue, would those assets be protected? The second part will cover off on an area that's asked more commonly than not, in will it protect against a family law claim in the next generation? Certainly not going to protect against, say, mum and dad in the current generation, but if we use a testamentary trust, will that protect our children if they have a family law issue in the future, or our grandchildren? And it's a very common question for clients to ask because it is something that's often forefront in their mind. Mentioned we'll go through taxation of testamentary trusts, and then we'll also very briefly have a look at our version of a testamentary trust, the Cleary Hall Bloodline Wheel Trust. So asset protection generally. If we think about testamentary trusts, it will depend on how they're drafted, and I guess it's not safe to say that they're all the same. But if we want to have a testamentary trust created by will for a client, we want to make sure it has the most available asset protection. And that's usually by ensuring that our testamentary trust is what you would call a fully discretionary trust. So you'd be aware of discretionary trusts, people using them during their lifetime, whether that's to hold businesses or to hold assets. The analysis in terms of testamentary trusts is very much the same in terms of general asset protection. It will depend on the terms of the trust. If we have a fully discretionary testamentary trust, we will have all of the features and asset protection of a discretionary trust. In that, for beneficiaries of that trust, their rights are limited, and that's limited to a right to due administration, a right to be considered, and no beneficiary has an interest in trust property. So if we are the beneficiary of a testamentary trust, and it's a fully discretionary testamentary trust, and we are sued, we have no ownership interest in relation to that property, and those assets would be safe. I mentioned before, they're not all created equally, and it will depend on the terms of the trust, because it is sometimes common to see a default beneficiary being a particular child or children, or a particular end date for the trust where it all goes to a particular child. From an asset protection perspective, that's not ideal, because that could be creating an interest for that beneficiary. So it would be our preference in any form of testamentary trust that it is a fully discretionary trust to give that extra asset protection. Because if one of our clients' objectives is to make sure the assets are preserved for future generations, we want to make sure that we're providing the most asset protection that we can. In terms of the trusteeship, one of the things that the clients will struggle with the most is who is going to be the trustee of these trusts. And when I say struggle, probably not the right thing to say. It's more a consideration. It's the thing that they'll think about the most. Of course, with trusteeship, we could have individuals or companies acting as trustees of these testamentary trusts. One thing to consider, if we're drafting up our will document now, in order to appoint a company, we would need to have that company in existence now. So it may not be the case that the client wants to pay an ASIC fee for a dormant company until they pass away. So we could always appoint individuals and have a mechanism that a company be appointed. But in doing that, one of the things that we're going to need to consider is who are going to be the trustees, whether that's individual trustees or whether that's them as directors and shareholders of the corporate trustee. One of the things that we will often recommend, and it's for a couple of reasons, is the involvement of an independent co-trustee. And by independent, we mean somebody who's not a blood family member, so to speak. So sometimes people will ask whether brothers and sisters can be trustees of each other's trusts or co-trustees. And certainly in some of the cases that we'll have a look at, that's the case that they were. But generally speaking, our preference is not to have that in place because of the reality that brothers and sisters can sometimes fight. And so we don't want to put them into that position. The other thing in terms of the independent person, it can be a family member, can be a professional. And when I say professional, as in somebody like the public trustee or a person that provides trustee services. or it could be another form of professional in the form of another accountant or lawyer. We often recommend to clients that they consider appointing their accountant as a co-trustee, if the accountant is, of course, happy to take the role, because quite often they'll have the knowledge of the financial affairs. The accountants are required to act under a code of ethics and professional responsibility. Generally speaking, a fairly stable hand and conservative by nature. So that's something that we would often discuss with clients. In doing that, very often the flip side of that is that we limit that person's role to what you'd call the major decisions. So dealing with trust assets, changing trustees, terminating the trust. If any of those things were to occur, then the independent co-trustee needs to approve of it. Otherwise, the children or child who is the trustee have the day-to-day management of the trust. So, as I mentioned, that's something that the clients will often take the longest time considering as to what this looks like, because it's an important role. Who's going to manage the affairs after the both of them have passed away? If we have the rights of a principal or appointer within our testamentary trust, so usually they have the ability to appoint or remove trustees. One of the thoughts or questions will be in general asset protection. Does that expose the trust assets if that person comes under attack? It's pretty clear case law and has been for some time, since 1994 in Wiley and Burton, that right is a personal right. It's not a property right. A trustee in bankruptcy, for example, takes over your property rights, not your personal rights. So they can't take over the role of principal or appointer if you become bankrupt. There may be a mechanism in the deed that automatically removes you as principal or appointer if you become bankrupt, but the trustee can't stand in your shoes, so to speak, if that clause isn't in there. And that was the case in Wiley and Burton, and there hasn't been much movement on that since then because the court was fairly clear. So we know if we have a testamentary trust that is drafted like a discretionary testamentary trust, fully discretionary, that we're not going to have issues from a general asset protection perspective. So if our children come under attack because of a failed business or because of something that they did elsewhere, those assets are still going to be protected for the benefit of the family and for the benefit of future generations. The thing that we get asked the most when talking about testamentary trusts is, what about protection against family law claims? Quite often, people are very, very happy that their children are in a relationship, but also recognise that the chances are that there may be a breakdown in that relationship at some stage. And it's rough for marriages, it's roughly a 1 in 2 chance. So 48% of first marriages fail within Australia, according to the most recent statistics. So if I have 2 children, I know it's more likely than not that one of them will go through a family law breakdown. Of course, that could happen before or after I pass away. So it's not necessarily the case that we're only doing this because we've got worries or we're going through a family law breakdown as it is. But it's also thinking about in the future and trying to make sure, as I said, their objective being to preserve the family wealth moving forward, not just for the next generation, but for the generation after. Under the family law, the court does have what you'd consider to be trust-busting powers. So they can treat assets as either property of the marriage or as a financial resource of a party in relation to a trust. They could set aside transactions under Section 106B, which is about transactions that made in anticipation of a family law order. They also have the power to declare a trust as share, if that's what it is, and the power to alter the ownership of a third party under Section 8AA. So they do have fairly wide powers to treat trust property as if it is property of the relationship. But like with most things, devil is in the detail. And it's not just the case that a testamentary trust will automatically form part of a family law claim. And it's more about having a look at the terms of the trust and also recognising the case law in respect of it as to how we might consider structuring our testamentary trust. One of the, it's getting a little bit old now, much like Wiley and Burton, but it is in reality one of the was the High Court, so it's one of the highest decisions in terms of family law court's ability to access trust assets is the decision of Cannon and Spry. And if you've been to our presentations before on things like Bloodline Trusts, you would have seen us speak about it before, but for the benefit of those that haven't, we had Dr. Spry, who was a tax barrister, and like most lawyers, he knew better than everybody else. He and Miss Spry got married in 1978. They had 4 daughters. Unusually, he was the settler and the trustee of a family trust and had the power to vary the terms of that trust. Now, the marriage had some difficulties, and at that stage, Dr. Spry decided to transfer substantial assets from his personal name to other trusts that were set up for the benefit of his 4 daughters. He and Mrs. Spry weren't beneficiaries of that trust, and they weren't in control. So that's what he thought he would do to try and get around a family court order against the existing family trust that had been set up for some time, and from which assets had, for the most part, accumulated during the marriage. Probably not unsurprisingly, Dr. Spry was unsuccessful in that the family court very quickly unwound those transactions because they said that the transfer of the assets to the other trusts was done in anticipation of a family law court order, which, considering it was done after their marriage was in difficulty, was a fairly easy case to make on behalf of Mrs. Spry. And so the assets fell back into the original trust, and then it was a case of having a look at that trust. And considering Dr. Spry was the trustee, sole trustee, that power to appoint trust assets he had as trustee to Mrs. Spry fell within the definition of property of parties to the marriage. They also went on to, one of the judges went on to say that Mrs. Spry's right to due administration of the trust was property of parties to the marriage. Now that means, as I mentioned, a right as a beneficiary is very limited. One of them is a right to due administration, and the family, and one of the judges in the High Court said that the right to due administration was actually property, so it could be divided, valued and divided. So the short of it is Dr. Spry lost. Order was made splitting the trust assets, which, as I mentioned, was quite unsurprisingly when you look at the facts and the circumstances. Post Kennan and Spry, so when I can remember when the decision came out, there was a lot of trumpeting from various family lawyers about how trusts were dead from asset protection from a family law perspective. However, that's not the case, and certainly not the case with testamentary trusts. And of course, like with most things in life, different facts lead to different outcomes, but we really need to think about the proper structuring and administration. And to that, we can turn to some of the more recent cases that have involved trusts and family law after Kennan and Spry. One of them, which we'll mention, which came out fairly quickly after Kennan and Spry, was a case called Essex and Essex. So with that, we had 2 trusts, and this wasn't a testamentary trust. These were inter vivos trusts, so trusts established during the lifetime of the client. And we had 2 trusts set up by mum, and she gifted assets to those trusts. In that, one of her stated objectives, or the evidence before the court, was to protect her assets from James, who was one of the brothers' wife. In terms of the rules of each of the trusts, so for example, what you'd consider to be James's trust, he was an income beneficiary of the trust, but he was neither a trustee director nor an appointer. That role was appointed to his brother, and his brother's trust was a mirror of that, where his brother was appointed as a director, a trustee director and an appointer. James was appointed as a trustee director and appointer, and his brother was an income beneficiary. In that, the court ruled that there was no control by James over his trust. He wasn't a beneficiary of the other trust that was for the benefit of his brother. So the trusts were protected in Essex and Essex. As I mentioned, these weren't testamentary trusts. They were trusts established during a lifetime. So showing that, as I mentioned, it depends on the facts and the situation. Turning to a more recent decision, and this is the decision in Bernard and Bernard, which was a decision in Victoria. Time's a bit of an illusion in lockdown, but it was late 2019, the decision was made. And the factual scenario behind this was we had the husband and wife who had been married for 27 years. They had 2 children in their early 20s. 3 years before they broke up, the husband's father died. And from his father's estate, there were 2 testamentary trusts created for the husband and his sister. And the value of that estate was a tick under 4 million, so 3.8 million. In reading the decision, I kind of wondered whether the passing of this wealth was the impetus for the relationship to break down. But of course, unclear in the decision, but I suspect it may have expedited the breakup, considering the death was 3 years before the breakup. The husband might have decided it was time to go and do other things now that he had this access to wealth. In terms of the testamentary trust itself, so looking at the husband's testamentary trust, the husband was what was called the primary beneficiary. The wife and children were general beneficiaries. Both of them had the rights to capital and income. There was an independent appointer who was appointed. The sister was the trustee. In terms of the sister's trust, so to speak, it was a mirror image. So the same independent appointer was the appointer for the trust. The brother was the trustee. Sister was primary beneficiary, and her spouse and children general beneficiaries. Aside from that, it was what you would call a standard discretionary trust, in that it was fully discretionary, had all the normal sorts of powers that you would have. It was just in the form of a testamentary trust. So we trot along to family court. Before we do, worthwhile pointing out the use of the testamentary trust during their lifespan. Clearly, they'd only been in operation a short time before the court case, and as the court case ran on. It ran a property development in partnership. All income was accumulated, so there were actually no distributions to any beneficiaries. It was accumulated and taxed at the trustee at the top marginal rate. A husband was employed by the partnership on a salary, and that was a market rate salary. In going to the family court, the arguments of the wife was that her lawyers accepted that the husband didn't have legal control of his trust, but as it was a mirror image of his sister's trust, he had what they called real control. I guess it's a kind of like a vibe argument in the castle. It's the vibe of the thing. They also made the argument that due to the partnership, they had rights and obligations to each other, and that he exercises real control. Alternatively, they said that the arrangement was a sham, and that also the wife had rights as a beneficiary. Remembering she was a beneficiary, and in that case of Kennan and Spry, we had things like the right to due administration forming property of the relationship. So what did the court say? The court found that the wife, as a beneficiary, only had the right to due administration, and that right was very hard to value, even if they did find it was property of the relationship. In terms of the husband and his sister, they had what the court called meticulous documentation. So they recorded every decision that was made in relation to their trusteeship of their respective trusts. And there was no blurring of the lines where the husband acted as the assets of what you'd call his trust were his own, and vice versa in terms of the sister. So the easiest way to say it was dad set the rules and the kids followed the rules, and they didn't deviate from that. And that's very important, because we can establish the most fantastic asset protection structure that the world has ever seen, but unless the people in control of it follow the rules, it's not really going to mean anything when we get down to it. So in this case, they did follow the rules. They recorded things properly, and also the court clearly found that it wasn't a sham. These trusts were real. They came under the estate, and with that, the court found that the trust, the testamentary trust, was not property of the marriage, and was not able to be split up, and the wife failed. So good recent court judgment there, confirming that it comes back to structure. One, testamentary trust will provide protection against a family law claim, but we also need to consider our structure. So with that, control is clearly crucial. Hence the reason why we would always or often suggest to clients that they have an independent co-trustee involved. Of course, if we could have the scenario, such in Bernard and Bernard, that we have somebody completely independent as the trustee, and I'm not talking about brother or sister, I'm talking about somebody completely independent to them, and they're the sole trustee, that's even better. Of course, many clients won't make that leap. However, that's something that we should consider, but definitely having somebody else independent to act as trustee if they're trustees at all. Record keeping, that was made out to be a fairly major part in the case of Bernard and Bernard. They documented all their decisions. Clearly, proper initial structuring and advice would be crucial, but we can still provide protection from family law claims by using testamentary trusts, is the short of the decision, as long as we structure them right. So I think that certainly if a client says they want their child on their own to be trustee of the testamentary trust, we should point them to this decision, or point them to the fact that if they do that, it will be a weaker vehicle to protect against family law. That may not be a consideration of the client. They might not mind that, but we need to alert them to it. We can also consider the further protection of using what we use in our Bloodline Will trusts, and I'll go through the differences. So the Bloodline Will Trust was developed by us in the early 1990s, and there was a direct response to concerns by rural farming clients about the impact of divorce of children on the family business. So in those days, the firm did a lot of work for clients in North Queensland, predominantly cane growing clients up there, predominantly Italian immigrant background, lots of sons, not many daughters, concerns about daughters marrying the sons and making off with the family farm. So that's the genesis of the Bloodline Trust, and correspondingly testamentary trust version of it, the Bloodline Will Trust. Aside from being a fully discretionary trust, we also have other specific clauses in that capital can only ever go to bloodline descendants of the will maker, but income usually can go to bloodline plus other beneficiaries such as in-laws. It's not always the case, and we can make it whatever way that we want to, but usually we will have income to be able to split amongst a wider group of people, and that's generally for tax flexibility. But capital can only ever go down the bloodline, and capital distributions can only ever go down the bloodline. And there are clauses within the deed not allowing those clauses to be changed. We can't add to the bloodline aside from somebody being born into it. We can't vary the deed in that respect. So we're building in that protection, as well as other protection when you think about tax issues in terms of dealing with capital gains. The capital gain is, in effect, part of it is treated as income under tax law. That income can only ever go to bloodline beneficiaries. So making sure that we're building a wall between what you'd call the family and spouses, if either the sons or daughters go through family law issues. Because our first argument in this, aside from also building in those other protections that we saw in Bernard and Bernard in terms of control, is that the wife or the husband or the significant other could never have received any capital in the first place. So in order for the family court to grant an order, they would be breaching the rules of the trust in doing that in trust law. So very strong protection and increased protection from a standard, what you call discretionary testamentary trust. And hence the reason that we tend to use this in estate planning when dealing with testamentary trusts pretty much exclusively with clients, because these are the sorts of issues that they're generally wanting to address. In terms of the structure, and we've just got a diagram here showing how it would work with 3 children. So normally we would suggest that there are 3 separate trusts. Now, from a family law perspective, it would be safer if there was only 1 trust and we had the 3 children involved. However, we've also got to recognise practicalities. And the practicality is in that maybe not the 2nd generation, but definitely the 3rd. If the trust is still in existence, it's very likely that the descendants are doing different things and not as close to each other. So we want to give them the flexibility of having their own trust for that branch of the family, so to speak. So normally speaking, beneficiaries and then trustees as well would potentially be the other parent on the death of one, again, recommending that independent person to act as a co-trustee, and then the respective child in the estate gets split amongst the three children via their trusts. Trust law is never still, and of course, or the law itself is never still. So after Kennett and Spry, we did make some changes to our Bloodline Will trusts in that we had added a clause to say that if a beneficiary takes an attacking position against the trustee, it's paraphrasing that, they are automatically removed as a beneficiary, and that a beneficiary's right to due administration does not form part of the trust fund. So both of those in direct reaction to Kennett and Spry. The first one, it's a little bit open-ended as to whether it would work in a legal perspective, but like with many things, we take the view that it's better off to have it in there than not. Kate?
I just have a few questions for you, Adrian, if now's a good time.
Sure thing.
Okay, the first one is, I have a Centrelink aged pensioner who is a beneficiary under a testamentary trust. Is that interest treated as an asset under Centrelink aged pension eligibility?
It's a little bit hard to definitely say yes or no without looking at the terms of the testamentary trust. So if you want to email that through to the office, we're more than happy to look at it. But if the pensioner, or if the client doesn't have control of that trust and they're merely a beneficiary, and a discretionary beneficiary at that, then it won't be taken into account.
Okay, the next question we have, if the husband, I assume we're talking about Bernard and Bernard, if the husband utilised any income distributed to the child beneficiaries for tax reasons for personal use, would the decision have been any different?
It may have been, and that's, I guess, when I mentioned before, the different facts lead to different outcomes. Because the court will look at how the funds have been used. If they've been used, as you say, distributed to children because of the tax advantages and then used by the husband, they may take a different view. I mean, certainly, in terms of testamentary trusts and family law, they will be treated as a financial resource. So the court will recognise that the husband or wife may get some benefit from it in the future. But yeah, it's a bit hard to speculate just on that.
Okay, two more for you at the moment. Previously, you mentioned considering having your accountant as a co-trustee of the testamentary trust. Is co-trustee or sole trustee something that we, Cleary Hall, would offer as a service?
We do on occasion. I say on occasion, it's generally speaking where we have had a long relationship with the client, or where there's pretty much no one else that they can think of, and you're kind of like the trustee of last resort. We try to avoid it, not for the basis of that we don't want to do it, but the reality is with these clients, we don't tend to have a long-term relationship with them. We may do their wills, and that may be the only work we ever do with their clients. So we don't really know their family situation, and it's kind of a little bit, in my view, inappropriate for us to say offer it. But certainly, if asked, and if it's, as I said, if it's either a long-term relationship we've had the client, or we're the kind of like the co-trustee of last resort, and then we do it.
Okay, and then last one for the time being, a scenario similar to Bernard and Bernard. There was a spouse who paid $50,000 to settle the family law case in an attempt to save on their legal costs. Just a general question, what do you think about that?
I think it's probably pretty wise. And I've had this discussion with clients who have had testamentary trusts and they're going through family law issues. It's not always the case, but generally what they will spend, if they are willing to accept $50,000, they will spend that with family lawyers in a couple of months. So you do have, it becomes very personal, of course, and sometimes people are a little irrational, but you do have to still take a step back and think, if I pay $50,000, even if I fight and I paid lawyers that $50,000, I'm not guaranteed an outcome, whereas that $50,000 will guarantee me the outcome if I settle.
Okay, thank you.
Okay. Moving on to taxation, and obviously foreshadowed in one of the questions there is that there are taxation advantages of testamentary trusts. So a testamentary trust under the tax legislation is purely a trust created under a will or a codicil to a will. And we have a specific section in 102 AG that deals with different treatment of the income assessable, income that is accessible because we have a testamentary trust. Now, as we know, we have Division 6AA, which is in effect a punitive provision that imposes the maximum rate of tax on income on minors for inter vivos trusts. So if we distribute income to a child, anything above or around the 600 mark is taxed at the top marginal tax rate. So not really tax effective in terms of inter vivos trust or trust created in our lifetime. However, those same rules don't apply because we have exclusions where it's income that's coming from a testamentary trust. So with that, we have this concept of accepted trust income. So that's income that's coming from a trust resulting from a will or a codicil. So that's your classic testamentary trust. Income that's derived by the trustee from the investment of any property that devolved for the benefit of the beneficiary from the estate of a deceased person. So that would be the scenario where we have property that is, for example, held on trust until a person passes away. And then, so I'll step back and I'll read it. So we've got husband who leaves a property on trust for the children with the income to go to grandchildren until wife passes away. Something along those lines would be that. Or derived by the trustee from the investment of any property that's either falling under 1 or 2. So fairly strong tax advantages there in that accepted trust income is taxed the same as an adult taxpayer. So if we have a child, we can distribute effectively $20,000 to them and it will be tax-free. So very advantageous if we have a large number of minor beneficiaries that we could distribute to. Of course, I always say to clients, it's a great tax advantage, but in order for it to occur, somebody has to pass away and there have to be minor children at the time to take advantage of it. So it's not always going to be a tax advantage, but there certainly is some there. And certainly in discussions with clients that are using testamentary trusts in that manner where they're distributing income to the children, it's certainly a great tax advantage there for them in reducing overall tax rate. The flip side, of course, is that we also need to think about what happens when the children become adults. Because tax issues aside, clearly the tax treatment won't change. But when they become adults, they would be entitled to call for their entitlement. So if we've distributed $20,000 a year, year after year for say 10 years, and they become an adult, we haven't cash flowed it to them, then they would have an entitlement of $200,000 and they'd be able to call for that from the trustee. Or worse, somebody standing in their shoes, whether that's because they've gone bankrupt or whether that's because they're going through a family law issue, would be able to call for that. So it's important to keep on top of that. And usually it doesn't tend to be an issue because we can offset that distribution against amounts that are paid on the children's behalf, such as school fees or food or other things. So something just to bear in the back of your mind if you're doing accounts for testamentary trusts. There were some amendments that came through a couple of years ago to tighten up 102 AG, I guess you'd say. In essence, it only applies now to assets that pass by the will or codicil, if we're talking about testamentary trusts, and assets that are substituted or the growth on those assets. So those are the only assets that we don't get concessional tax treatment for. We can't have a testamentary trust, for example, that has $10 in it that's passed under the will and gift an asset to the trust and have concessional tax treatment. That's not going to work anymore. So with that, those amendments came through a couple of years ago, so just to bear that in mind as well, that it's only assets that pass or their substitutions or their growth that we get concessional tax treatment on, or that are accepted trust income. One thing to consider in relation to just generally in terms of testamentary trusts is we do need to think about the nature of the assets that are passing in the testamentary trust. So something like the family home, for example, is it appropriate that it goes to a testamentary trust? Because then it could be exposed to land tax, for example, or it could be also loss of the main residence exemption if we pass it to a testamentary trust. There are mechanisms with dealing that, but that's something to consider in terms of what's in the estate. Is it better that the house goes to the surviving spouse? If both spouses pass away, what's the likelihood of the children keeping the house? What are their ages? Do they need to live in it? Would they sell it and move on? So that's something to think about, the nature of the assets. We also need to think about if we're putting something into the trust that will incur land tax. So whether that's residential property, well, mainly residential property because they're the ones that have the surcharge. That in a lot of states now, there is this concept of a surcharge on land tax for what they call foreign trusts. And say, for example, in New South Wales, where I practice, there is a surcharge on any discretionary trust, which includes testamentary trusts, that hold residential land that haven't excluded all foreign beneficiaries and also have a mechanism to say that you can't amend that exclusion. It's not an issue yet live for testamentary trusts, but it will be at the end of the year, in that up until now, if we're signing will documents, the surcharge won't apply. However, any will documents signed after the end of the year, there's the potential for land tax surcharges to apply in New South Wales. So something to bear in mind, again, thinking about the nature of the assets. Do we need to change the terms of the trust to make sure that we're not slugged with any land tax surcharges if they're going to keep the assets? Well, hopefully today the topic was, do testamentary trusts work? Hopefully I've been able to show that they work from a general asset protection perspective as well as a family law perspective, that they still have benefits from a taxation perspective. So the short answer would be, do they work? Yes. Certainly something that you should consider for clients who have any of those concerns or have a significant estate. Clearly, if we can put them into a will or a structure that has ongoing protection of those assets, as well as tax advantages down the track, as well as protection from family law claims, then we're going to, on the most part, be meeting a lot of clients' objectives, because I can tell you that those are mostly the things that clients talk to us about as their concerns and objectives. Any questions?
No, there's no further questions at the moment, but we'll give you a couple of minutes. If you have any questions on your mind, feel free to shoot them through, and Adrian can answer those questions now. Here we go. Okay, so the first one is, how much asset value, or what asset value needs to be in a testamentary trust to make them worthwhile?
There's not an answer. The short answer is it depends. If you think of ongoing costs for the testamentary trust, they're going to be accounting fees for the tax return. As long as in reality your income being derived from those assets is more than the accounting fees, then they may be worthwhile to the clients. Having said that, I would have thought 500,000 up would be the kind of sort of thing that you'd be looking at in terms of asset value. I have had testamentary trusts that were continued to be used where the assets were only 100,000. But that was mainly because the clients in that circumstances wanted to make sure that they followed their father's wishes in having the testamentary trust as a protection for that 100,000. They recognise that it's probably not cost effective, but that was their dad's wish that 100,000 was protected.
Okay, another question, similar vein. If you were to distribute $40,000 per year to each minor beneficiary through a testamentary trust, what would be a reasonable amount to offset those entitlements? With respect to inter vivos trusts, if the minor is only receiving $416 of taxable income, it is quite easy to argue offsetting this.
Without wanting to be glib, I would suggest sending them to a very expensive private school. You'll very easily offset that $40,000. But in all seriousness, yeah, it can be difficult. So then you may look at, when they get to 18, if there still is an amount there, that you could consider having the child, in effect, renounce that entitlement at that age.
Okay, we have another question here. Does a particular asset need to be itemised on the will in order to be eligible for the tax concession?
No, it doesn't. Obviously you need to show that it passed under the will, but it doesn't need to be itemised in the will. It is a bit of and it's one of those things, it's a little bit of an administrative nightmare if you put other assets into the testamentary trust, because then you'd in effect have to have two separate books of accounts. But yeah, it doesn't need to be itemised.
Okay, I think we have one final question. If you were to appoint an accounting firm to be the trustee, can the person establishing the testamentary trust enter into an agreement to ensure their wishes are fulfilled, or do you leave that to the trustee's total discretion?
On the basis that we will always want our trustees to have discretion, we wouldn't have them enter into an agreement. We will generally have a separate document, which is we title a letter of wishes, which will outline what the wishes of the client are, and that they want the rules to be followed, so to speak. I haven't ever seen it be an issue that the trustee didn't follow the wishes of the client. There's only a couple of, when I say haven't, there's a couple of occasions where they couldn't follow it. And an example of that was there were actually no assets left. But aside from that, it's, we wouldn't want to be binding the trustee to certain things in the future.
Thank you. That's all the questions we have for now.
All right. Just a reminder that we will send out a feedback email post-webinar. So as I mentioned, this topic today is from a request from an attendee. So if you do have topics that you want to hear about, let us know.
All right. Thank you very much, everyone. I think we'll close it off there, and we hope to see you in a fortnight for our Ask the Experts roundtable discussion. Thanks, you.
Thanks, Kate. If you call yourself an expert, it must make you one. So thanks, everybody.